May it please the court. Chantel Suttle here on behalf of Mr. Keith Hopkins. Mr. Hopkins, well, this is a case regarding Mr. Hopkins' unfortunate, I guess if you will, oxymoronic situation. This matter started briefly where he was on probation back in 2016, 2000 through 2021, placed on probation for 4 years, October 11th of 21 by Judge Lammy. Sometime in 23, unfortunately, someone apparently became angry, made allegations against Mr. Hopkins. There was a case filed, went up, was appealed, basically to circuit in error. Has since the appeal has been filed, that case has actually been, the indictment rather, has been dismissed and expunged. That particular motion or error was also mentioned in our initial appeal because at that time it had not been, and the judge had actually denied my motion to dismiss it. Well, since that time, the state has actually dismissed it, the indictment that kind of started all of this, and it has been expunged. But we're still here because during that process, the court ended up finding an order that said, on one hand, by Judge Lammy, he should not, Mr. Hopkins, should not be released back to probation. Then there's a second order that says, hey, we give him probation for 4 years. And not only Mr. Hopkins, but the court and the probation officers relied on that from 2021 all the way until basically 2025. Actually, in about 5 days, he would be finished with the probation had he not been involved here. But the fact that he was brought back before this court for a case that has now been expunged and dismissed, and he's still been incarcerated since this started.
So just so I'm clear about that, what triggered this violation of probation was an allegation of some type of harassment charge?
Yes.
And at the time that y'all had this violation of probation hearing, that was still an active charge. It had not been, I guess you've now indicated that it's been dismissed and expunged. Is that correct?
Yes, Your Honor. It was dismissed and expunged twice. During the actual hearing, because it was a brother that he has not seen in 3 years.
The actual hearing, in which court?
Well, in the, I guess the underlying court, the General Sessions Court, because the brother decided he did not want to proceed.
On the harassment charge?
Correct. And the state, after talking to the brother, talking to everyone, communicating, decided that they would just dismiss it and would not proceed further.
In General Sessions Court?
Yes. We ended up the following year receiving an indictment on that particular case.
So the state apparently did a direct presentment to the grand jury.
In error, and they indicated to the court this was an error. Even in the transcript, the new prosecutor upstairs didn't have a clue what was going on. The file actually from another case was in there with this other case. They didn't have a clue what was going on. So they wanted to go and talk to the prosecutor downstairs to find out if what we were stating was accurate. And we had the order of expungement signed by the judge, the other attorney, and all of that. And so they agreed it was an error and that they were going to go ahead and dismiss it. However, they were in no hurry to do so.
Okay, but my understanding is that that harassment case was not proceeded on in the violation of probation. It was not a ground. Is that correct? The state didn't act on it.
Correct.
Okay.
Correct. But because of all of that it was still open. And that's where we were with their alleging, hey, he's violated, he got this charge, because that's what's on the face of the affidavit.
But the state didn't proceed on that. They proceeded on some other allegations. like absconding?
Well, yes, Your Honor, and the judge did not address that, and I guess that's one of the issues that we have. It boiled down to that after the other, because the judge in this same case, because it had not been dismissed by the state yet the second time, because they were still, I guess, just going to wait, but the judge states in the transcript, well, they said they're going to dismiss it, so one day they will, so, okay, we'll wait, but right now I'm going to deny the motion.
This
Well,
case, I was so confused when I tried to follow what actually happened by reading both your brief and the state's brief that I went into our system and read the transcript from that hearing, the violation of probation hearing. I was even more confused after I read the transcript from the probation violation hearing. There were stops and starts, and we're going to try to find that indictment, and then, the whole thing was just very confusing, to say the least.
And that's why,
And
because
ultimately, it sounds like the trial judge just said he should have never been on
Exactly.
probation in the first place.
so she said regardless, and she even says, well, not that he did anything wrong, not that he did, but he still shouldn't have been on there, and it's time for him to go do his time. Because Judge, I have to follow the order, ma'am, I just work here. Okay?
That's what the
but
trial judge said, is, "I just work
and
here."
she says, and it's in here, I have page and number, if you'd like it with the transcript. And she indicated, the court speaks through its orders, and I have to follow court orders, no. I don't know if it was an oversight or blank, blank, I don't know, I don't think any of us were involved. And I don't think there is any collusion, I just think that he was supposed to go on, not go on, she said that he was supposed to go on probation, but I assume she meant not. But guess what? She said, I just don't think that he was supposed to, not that he did anything, not that he complied, but he was never, that wasn't supposed to happen.
It sounds like the trial judge didn't give you much opportunity to explain yourself, but, following her reasoning on this, if this probation, your client pled in 2018, 5-year sentence, and apparently that plea agreement says he does not get a second chance at probation. Is that correct? Am I right so far?
That's what they say. I wasn't the attorney, and like I said, there was so much confusion with the orders because Judge Lammy signed the order that gave him probation October
Okay.
11th.
So then we rock along until October or 2023, when apparently Judge Lammy signed an order that extended his probation.
That was in 2021, October 11th, 2021.
Okay.
Both
But
orders were the
which
exact
order
same date.
Which order was it that this trial judge was relying on that said he never should have been on probation?
Both. That was the problem, and that's why I said there was an issue, and we go through that on several parts of the transcript, and she says, hey, I'm done thinking about this case. He just needs to do his time, appeal me. But the problem is, she said he was never supposed to be on probation according to the court's order. And this is page 26 of the transcript. And then I say, and then she says, Judge Lammy did allow him, that was talking about the driving. And then she said the court speaks through its orders, and I have to follow the court orders. And she talks about it possibly being an oversight. And then I mentioned, well, I understand. So if you have to follow the court's orders, and this man has been on probation now, we're almost 4 years in at that point, and he's almost finished. And so wouldn't it stand to reason, and wouldn't it make sense to say, well, okay, the judge did sign saying that he has 4 years of probation, so maybe this one is in error, the one that says that he's not. But you have competing orders, and that's why it's this oxymoronic situation where you have two orders signed by the same judge on the same day, and one says, revoke we're going to revoke the suspended sentence, and then the other says, hey, we're allowing you to be reprobated. And it's even stated in the form by the Department of Correction that he was reprobated on October 11, 2021.
Okay, let me stop you for a second, because, and again, I haven't pulled up everything, but the state pointed out that the original plea probation order were not included in the record. Is that correct? The 2016, the indictment and all the paperwork from 2018. Because 2018, when he was originally put on probation.
Yes, Your Honor.
And that would have been the order that would have said you can't ask for suspension of remainder if you're violated. Is that correct?
That would have been, that's what they were speaking of.
Okay, and that's not in the record?
Correct.
Okay.
'Cause we don't,
All right, and so then there's a violation and the judge reprobates him in 2021?
correct.
Okay, all right. And then that is the order that that's in front of us now?
That's what we're asking for.
But you're...
Both of them are. There are
Both?
two orders. There are two orders the exact same day, October 11,
Well, I understand
21.
that, but what the judge did was he revoked the initial probation and then reprobated him, is what he did. So there'd be two separate orders.
There are two separate.
Okay, well, that's what he did.
Okay.
He revoked the old probation, then
Okay.
reprobated him.
Correct.
Okay.
But this judge who's sitting now obviously doesn't see it that way. And she's like, well, he never should have been on probation. Don't you see this? And she talks about it for 2-3 whole pages. We're going on and on and on and on. And she says, well, the court speaks through his orders. He never should have been on probation because here's this order that says it's revoked. And I'm like, yeah, but the judge signed saying he's reprobated. I have to follow the court's order, and it clearly says it was revoked. So I don't know. She said, I don't know if it was an oversight by him signing the other one saying he is on probation. So he's going to jail today because he shouldn't have been out for these 4 years, 3 and a half
I understand, and I guess the reason I would like to have that 2018 order is because if the order said that the defendant could not petition for suspension of remainder, then that's not really what happened. Because he never petitioned for suspension of remainder, the judge just reprobated.
What does, I'm seeing a term here in the record that apparently you guys use over in Shelby County that I am not familiar with. I'm sorry. PSRS.
Petition to suspend remainder of sentence.
Okay. According to the record, that's what the 2016 order says, according to the judge. She says, imagine my surprise. Condition number 6 of the original order signed by Judge Lammy on January 14th, 2018, no PSRS.
No petition
If
to
violated.
revoke,
And
suspend
that
the
means
sentence.
no petition
No,
for,
petition to suspend remainder of sentence.
is that a Shelby County deal? I mean, I was a trial judge for 16 years in 4 counties, and I never saw that I'm aware of.
It's if you're in custody and you're asking the court to grant you probation, basically early release or whatever you want to call it, probation, from they would file them from the correctional center.
Okay. I'm now questioning my colleague.
No, and I'm like.
So it is a Shelby County thing.
It is a Shelby County.
Okay.
Yes, and so Your Honor sees the dilemma that we have, and it makes perfect sense. Okay, he has to revoke it and then reprobate him, so that means he can be on the probation, and everyone for 3 or 4 years acted accordingly. But this judge came in, and because she sees both, she's confused, and she says, hey, none of us were here at the time. I understand, and you understand my confusion, but the court speaks through its orders, and I have to follow the court orders. Whether it's an oversight, she said, I don't know. I don't think any of us were involved, and I don't think there was any collusion. I just think he was supposed to, I don't think he was supposed to go on probation. And so that was our reason, aside for the motion that has now gone away, as far in terms of the indictment. But that's what got this ball rolling. If we wouldn't have, I guess.
Well, let me ask you this about the ball rolling. Let's just, whatever order this trial judge relied on to say he should never been on probation in the first place, did your client and you have an opportunity for a consequence hearing on a probation violation? The second stage of Dagnan that requires a trial judge to consider what's the appropriate consequences.
No, we had this hearing with this lady who was alleged probation officer who didn't even have a file, and that was another thing that I kept questioning, and that's another contention of the error, abuse of discretion.
But that was part of my confusion as well, I guess, because this case bounced back between Shelby and Tipton and Shelby and Tipton.
And Jackson.
Who was the
because
probation
she's in
officer?
Exactly. That's how he had dealt with one particular person, and we're like, where is he? Well, I don't know. He doesn't work here. But you're testifying about his notes. I said, do you have his file? Are you the custodian? Is there a foundation? And then the judge goes on, and instead of basically why I'm basically questioning the evidentiary admissibility of her testimony and foundation, because she said she didn't bring her file. She doesn't even know whether there's his number for him in the file, but this man has been talking to him all these years. And so then the judge goes into, for a whole 2 pages, and because I question admissibility, instead of the DA laying the foundation so that the judge can decide whether the testimony is admissible in those records that she's testifying from, the judge voir dires the lady for 2 pages. She asks her all the questions as if she's the attorney for the state.
So the judge is examining the probation officer?
For the whole 2 thing about the admissibility. And then when she gets all the answers, she looked at me and says, did I misunderstand your objection? Because she went through and she asked her, and I said, well, that's what I was asking her. But you basically gave it, and if the lady gave a certain answer, then the judge would say, oh, and that's just not your fault, right? Or that's just this. So it's like.
The judge would say that's not your fault?
Yeah, she went through she was the attorney at that point. And I'm sitting here like, well, the state didn't have to do anything. They objected to me asking. And then after that, the judge started asking the probation officer all the questions that the attorney would ask to cure my objection. But the judge did, and she's the one who has to make the decision. So guess what? She knows what answers to elicit. She knows what questions to ask, and that's not how that should have gone. And so at the end of all that, because I'm questioning this lady's credibility, I'm questioning the fact that she says she doesn't even have her own file, but she claims she's the officer. She claims that she went to his house months before she even stated that she got the caseload. So she was all over the place, and she should not be found credible, and she's testifying for somebody else's record, like, where is he? And so then I get jumped on also about asking the questions about that. Everything is objected to, like, but you're testifying about his records. What's your authority to do that? So all of those things became an issue because that's what the judge was relying on. So when I make that last statement, her thing is, well, I tell you what, regardless of all of that, he shouldn't have been on probation in the first place. Give me the revocation order, because the court speaks to his order. I'm sorry, appeal me. And I'm still talking, and she says, well, I'm finished, I'm done with this case. And so just appeal me. And that's how we got here, because there are a lot of issues, and we believe there was abuse of discretion on multiple levels in this case. And unfortunately, because of her reading of these 2 orders, one which apparently she hadn't been taught to read it, like, Your Honor, he had to do this, and she doesn't understand that. She's confused by it, so she's thinking because she has something that says it's revoked, then he should not have been on there at all. Regardless of both orders were given the same thing, like, well, wouldn't your discretion allow you to say, wait, I have 2 here. This says he's to be out. This one says he's to be in. So obviously the judge must have meant for him to be out, or he would not have signed it. So let's err on the side of caution, at least until there's appeal. But her answer is, I'm done talking with this case, talking about this case, and so just appeal it if you don't agree. And that's page 29 of the transcript. She said, I've already ruled when I was asking her about it. I said, guess now we have this at the time of the revocation. And she said, I've already ruled. Where's the revocation order? I'm done talking about this case. Mr. Hopkins needs to do his time. Appeal me. And I'm still talking, and she's like, that's it. And the other attorney said, we filled it out for you, and then they passed it to her. And then I asked, which order are we going on? Because we still have 2 orders. We still have 2 orders. So I'm still talking about it because it's not clear and nobody knows what's going on. So I'm like, okay, so which one are we going to proceed on? I said, and that's what I want to clarify, Your Honor. Which order are we abiding by? And she said, what do you mean, that order? I said, well, if Your Honor is saying that the last probation is not, and then she said, valid. And then I said, right. So that's why we're here. And we're asking that Your Honors will look at this situation. Thank you so much.
All right, thank you. General, good morning.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. I'm filling in for Kirby May, who is enjoying a much-deserved vacation. Like Your Honors, this case is a bit messy, and there's a little bit of chaos there. But so I'd like to sort of talk about the procedural history, and also to your point, Judge Campbell, of what we have in the record and what we don't have. And I think that might help clear things up and prevent this from being so messy, as well as getting rid of a few red herrings that really aren't important. Starting at the beginning, this appears to be a case that arises in 2015. We do not have the charging document, whether it be an indictment or an arrest warrant or whatever started these underlying cases. We don't have it, but based on the record, it appears to have stemmed or arisen in 2015. In 2018, the case was resolved somehow. Again, we don't have the judgments for these convictions, so I honestly can't tell if it's a guilty plea hearing, if it's a trial, or what. But ultimately, the defendant is convicted of aggravated assault, theft of property over $1,000, and domestic assault in 2018, and receives 4 years of probation. While he's serving that 4 years of probation from 2018, about 3 years later, in October of 2021, he violates the conditions of his parole or of his probation for the first time. And instead of getting fully revoked or anything, what happens is the trial court revokes it and reinstates the 4 years of probation. So now he's again on 2021. He's got 4 more years of probation. Shortly thereafter, this is all a Shelby County case. Shortly thereafter, he transfers his probation to Tipton County in 2022. And at that time, he's under the supervision of Officer Ford.
Which county? Tipton?
Tipton County, is I believe. So he transfers it to Tipton County and is under the supervision of Officer Ford. Officer Ford supervises him for approximately a year, and in that 1 year, Officer Ford sanctions him for violations, for technical violations, at least 3 different times, and also makes significant notes that the defendant has failed to report, has failed to provide sufficient documentation, because one of the conditions of probation is this defendant, it seems like he's a truck driver, and he is allowed to drive his truck and leave the state as long as he provides supporting employment documentation.
Did this probation officer testify at the
He did
violation
not.
hearing?
Officer Ford was no longer with the Department of Correction probation office at the time of the hearing.
Did Officer Moore have his file?
Yeah, she inherited his file. So what happened was Officer Ford supervised this defendant for approximately a year. At some time, Officer Ford filed an initial probation violation report, which would be the petitioner's second probation violation. That initiating violation is not in the record either. So that gets filed, I presume, sometime before October of 2023. In October of 2023, Officer Ford leaves, and Officer Moore joins probation. And she inherits this defendant's file along with all of the other Tipton County files.
So was Officer Moore a Shelby County or Tipton County probation?
Tipton County.
Okay.
Is Madison, it shows, so I believe her office is in Madison County, but she said their office supervises Tipton County, where the defendant had transferred his probation to. So she was supervising this out of Tipton County. She tries to work with this defendant for a year, around a year.
So if this defendant wants to report to Officer Moore, he has to drive from Tipton County to Jackson?
That's my understanding. And that's just the way that the offices are set up. And again, that's discussed at the hearing, but it's ultimately irrelevant. The defendant has gotten this legislative largesse. He's transferred his supervision to Tipton County. The Officer Moore is in charge of that, and she is in Jackson. But she attempts to work with this defendant for over a year while this initial violation report has been pending, has been filed by Officer Ford. During that year, Officer Moore conducts home visits. She goes and visits him or sends letters to his house. She attempts to call him, and she testified she got the same phone that Officer Ford had. So to the extent that there's phone communication or numbers at issue, if Officer Ford is able to contact the defendant, Officer Moore should be able to contact the defendant unless he's evading her. So she calls him, she sends him letters, she goes to his house. For a year, she tries to get in contact with him, and she can't. And at that point, in October of 2024, she files an amended violation report. And that is the first thing that we have in this record.
Well, let me stop you just because I think I want to get down to the brass tacks, so to speak. She testifies about this information. Does the judge ultimately just push all this aside and decide this based on the order? Or does she make findings about absconding or things like that?
So we certainly don't have crystal clear findings. What we do have is the court at the beginning of the hearing discussing that what we're going to look at here are allegations of failure to report, absconsion, failure to allow officers conduct a home visit, all of which are in violation of Rules 1 and 6 of his probation.
Okay. And I know from your brief, you talk about the things that she could have found. Did she make any findings at all other than, I don't think he should have been on probation in the first place?
So they're not that I'm aware of, and I think we're sort of shifting towards the consequence when the court is looking at that. The court implicitly finds, based on Officer Moore's testimony, both about what Officer Ford said and in the notes, because there's some question about admissibility and things. She testifies also about her own experience of this 1 year of the defendant continuing to evade her. So the court implicitly says, well, that's just absconding. Now what's the consequence? And looking back, now I'm trying to figure out the consequence, and goes back to this prior order confusion.
Okay. Did the trial judge give the defendant an opportunity to testify?
The defendant never asked. So at the end of Officer...
Well, when the trial judge just says, whoa, we shouldn't be here in the first place. I'm tired of dealing with this case. Appeal me. He needs to serve his sentence. Am I misreading that transcript?
So Officer Moore finishes, and the defense attorney says, I have no further questions. Seems to indicate that we're sort of done with proof. So I don't think that there's any indication that the petitioner wanted to, or that the defendant wanted to testify on his own behalf at this hearing.
Would you agree with me the trial judge did not give him an opportunity? Did the court turn to the defendant and say any proof from the defense?
Not in as many words, no.
Yeah, because I got the impression that when she had no further questions, it was for that witness, not that they were resting.
Possibly, but the defendant has not raised that issue. There's no contention on appeal that the court precluded him from testifying or from calling any other witnesses. Their sole complaint is with the finding of a violation.
Well, what violation did the court find?
Absconding, based on Officer Moore's testimony, both with the defendant's continued evasion of Officer Ford and then a full year of evading Officer Moore. And the proof overwhelmingly establishes that. Even if this court reads the transcript a little bit differently and says there really aren't any findings, this court can conduct a de novo review, and the record abundantly shows that this defendant absconded for over a year.
How is Officer Moore's testimony not hearsay?
Because she testified about her own experiences. So again, the defendant talks about admissibility at the beginning. I didn't see any objection in the transcript.
Do you disagree with your friend's description of what happened? The trial judge kind of took it over?
I think the trial court did take it over a little bit, which it's allowed to do. The rules of evidence allow the court to ask clarifying questions, and that's what it was. It wasn't And certainly at the end, it wasn't, well, there you have it, hush up, defense counsel. It was, what is going on here? Why did you get this case? How did you inherit this case? Did you handpick this? And it was ultimately the court and Officer Moore having a discussion of Officer Ford left. I came in. I got all of Officer Ford's files. And I think the language that my friend on the other side might look at is it just sort of happened, or it just happened that way. And that's about Officer Moore getting all of Officer Ford's files. I came in, I got all of Officer Ford's files. It just happened. But there's certainly nothing about evidentiary complaints, even on appeal. But even if this court finds that there's some question about Officer Ford's notes, the proof based on Officer Moore's experiences alone, personal firsthand observations, overwhelmingly establishes absconding. Again, she took over supervision in October of 2023. For a full year, reached out to the defendant by phone with Officer Ford's phone that had gotten in contact with the defendant before, sent him letters at his registered address, went to that house and tried to do a home visit and was unable to reach him this entire time. That proof alone, a year of failing to check in, failing to answer phone calls, failing to answer a letter, failing to be present during a home visit, constitutes absconding. And so even if this court wants to throw everything the trial court said outside, wants to throw all of Officer Ford's notes out, the proof based on Officer Moore's testimony alone of her experiences overwhelmingly establishes that this defendant absconded.
Okay, that gets to the violation portion. And under Dagnan, what argument do you have that the defendant was allowed an opportunity to present proof for consequences? And did the court consider anything for consequences?
So my recollection of Dagnan is that it is not mandated that the defendant have a separate, independent. Actually, I know Dagnan does not say a defendant is entitled to a separate hearing about consequence. What Dagnan says is it is a two-part consideration by the trial court. So you have to consider whether there was a violation, and you have to consider what the appropriate consequence is. There's no mandatory thing that the defendant has to be able to present additional proof once we get to the consequence.
But it has to be a separate consideration.
It has to be a separate consideration. And again, we would submit that once the trial court starts talking about this prior order, that it has shifted after making an implicit finding of a violation, it has shifted to the consequence. And even if this court says that, okay, well, you shouldn't have looked at that or anything is wrong, on a de novo review, again, this defendant absconded for over a year and already violated the conditions of his probation once in 2021, and then performed multiple technical violations while he was on supervision this second time. So I think the trial court's reasoning, even though it's inartfully worded, is you've gotten multiple bites at the apple. You probably shouldn't have gotten this in 2021, shouldn't have been reinstated to probation, but you certainly have now gotten a second chance at this legislative largesse, and you flaunted it once again. The fact that you've done these multiple violations, including absconding for over a year, warrants full revocation and ordering of confinement.
But just to follow up on what they're saying, if you were the trial judge just now, you've made some excellent findings and appropriate findings based on the proof that you would have heard. It sounds to me like when this trial judge got to this point, this shifting to, wait a minute, we got an order here, you shouldn't have never been on probation in the first place. Serve your time. I don't see that as being a consideration of what the consequences should be for the violation.
So it's certainly inartfully worded. I think if you look at the way that the violation was submitted to the court, in conjunction with, oh, you should have just gone to jail back in 2021, it's also, you shouldn't have gotten probation a second time. Like, you've done this multiple times now. But to the extent that this court has issues, and admittedly, this trial court's rulings are not great by any stretch of an imagination, this court can just conduct its own de novo review.
That's an interesting point you bring up. I'm sitting here thinking about that. Have we stated, or did Dagnan state, that we can do a de novo review for consequences?
I don't know if it's specifically Dagnan, but this court, Buys and its progeny, has always said that this court can conduct de novo review if it determines that the trial court erred. whether that be the length and manner of the length of sentence, the manner of service, consecutive. This court frequently does it when a trial court fails to make Wilkerson findings.
So
And we would-
you're equating consequences in terms of Dagnan with fashioning a sentence.
I think with anything, with all sentencing, it all falls under the same umbrella of length, range, manner of service, alignment of sentences, and then appropriate consequence for violating. I think they all fall under the same sentencing umbrella, and this court's, in our Supreme Court's Byes case and its progeny.
So just so I'm clear, it's the state's position that for a Dagnan-type consequence hearing, we can exercise de novo review.
Not a hearing, but for the consequence if this court were to determine that a trial court failed to make the adequate findings necessary for either the violation or the appropriate consequence, and the record supports de novo review, this court can do that. And here we submit that the record does support that. Whether it be violation or consequence, the record supports that this defendant absconded for over a year, and that the appropriate consequence after multiple bites at the apple and flagrant disregard for the conditions of probation is worth full confinement.
Well, there's other considerations that need to be taken into consideration, I guess, too. And most of the time that comes from a pre-sentence report in a sentencing setting, or a defendant taking the stand, probationer defendant taking the stand and testifying why he or she is entitled to some other consideration other than full revocation. And we just don't have any of that.
Well, so I don't believe there's ever a pre-sentence report at a revocation hearing. And what the
No,
court,
I'm not suggesting there is. You're the one who brought up the de novo
Certainly.
sentencing, and yeah, we've got a lot in the record to consider, but had a probation violation where the defendant is not given an opportunity to put forth any other considerations, what do we have?
Well, so again, the record shows the defendant never asked to testify or to put on any proof, and frequently they don't. Frequently, the court is just left with the facts of the violation. And it is certainly Dagnan, the footnote in Dagnan specifically says, you're allowed to look at the seriousness of the violation in and of itself when considering what the appropriate consequence is. And here we have not just the seriousness of the violation, but also the fact that it is multiple violations the defendant has committed now. So even if the defendant doesn't testify, there are enough things in the record for this court to consider and to weigh the factors of the appropriate consequence.
But now, when you're talking about the consequence, and again, we're talking about the record, there's a lot of this record that's missing. I mean, as far as the whole foundational paperwork of the plea and everything else, we don't have it.
Certainly.
We don't have the original probation order. We don't have the facts of the case that were stipulated to. We don't have the original pre-sentence report. We don't have anything. We just have this hearing that was abruptly ended. I mean, that's basically what we have.
Correct, but when we're looking at whether the defendant violated his probation and what the appropriate consequences are, I think this court can look at, again, we know that it's multiple violations, and we know what the facts are here. So again, we submit, the record is certainly lacking in a lot of things that would help inform this court, especially as the procedural background. But when we're looking at just did he violate, what's the appropriate consequence, state submits that the record is sufficient for those.
You mentioned typically a defendant may not testify, but I think typically after the state has presented the evidence to support the violation, the defendant, the trial judge says words to the effect of, defendant, would you like to testify, or would you like to present any evidence in this case? And it sounds to me like the way the record, from what I've heard, I tried to decipher, that by the time we got to the end of this witness, the trial judge made it pretty clear that this hearing is over. And so I'm not sure that we can say, so if we're going to do a de novo review, as my colleagues have pointed out, we don't know. Well, I guess what I'm saying is, I'm not sure any defense counsel who practices law in this court, in Shelby County, in this particular judge's courtroom is, when told, this case is over, this person should never have been on probation, I'm done with this, if you don't like it, appeal me. I'm not sure that any defense lawyer should be required to stand up and pound the table or demand to be heard, anything else. I pretty much would say, if I was in defense counsel's shoes, I'd pretty much, okay, well, I'm done here. I guess she's right. I'm going to appeal her, which this lawyer did. The point is, it seems to me like we're missing. By the way, you've done an outstanding job arguing a case for one of your colleagues and putting the best possible view of it from a standpoint of us saying, well, yeah, maybe the right result was reached. But I think what we're concerned with more than the right result is the process of getting to the right result needs to be something that we feel confident was a fair procedure. And that's I'm just telling you, that's what I see the problem with this case.
I understand. If I may briefly.
Go ahead.
Thank you, Your Honor. I understand this court's consternation, and certainly if it decides to send it back for clarification from the trial court to make better findings, that's certainly within its prerogative. All the state is submitting is that for the sake of judicial economy, with the record that we have, lacking as it is, it's sufficient for this court to independently conduct a de novo review and affirm.
Well, on that point, may I?
Go right ahead.
Why should we give the state a second bite at this apple? Why shouldn't we just dismiss this and why should we give the state a second bite at having a revocation hearing?
So I don't know if dismissal is appropriate in this situation because the state put on proof of violation. And so this certainly doesn't fall on the fault of the state. To the extent that there's an issue, it's the trial court didn't make sufficient findings. And so the remedy for that is to remand for the trial court to make better findings. Or if this court has expressed its consternation, is the defendant maybe not being able to put on proof, the remedy there is for the defendant to be able to do that, not outright dismissal of the revocation.
But let's say it's a case like, are you familiar with the Oden case, Daniel Joe Oden? It's now a reported case similar to this, where we found that the officer who testified was all hearsay. And the rest of the hearing went pretty much like this one. And I believe in that case we remanded it back to Montgomery County, I believe it was. But the thought occurred to me, why should we give the state a second bite at the apple when they have presented bad evidence?
And I do recall that case. I think that Judge Greenholz might have filed a concurring opinion differing in the results, saying that they shouldn't have gotten a second bite. The distinction here is that in that case, this court said it's all hearsay, there's no proof. We have Officer Moore's independent analysis of
I guess
her experience.
I'm just doing a hypothetical for you. If we ever get another case like Oden, shouldn't we just dismiss it, as Judge Greenholz apparently suggested?
I think that would certainly be an interesting case before the court. Because this case is different, we submit
You're not
that.
taking my bait.
No, Judge. Again, we ask this court affirm, but understand its consternation. Thank you.
Thank you.
Thank you, General. I don't know if did you ask for rebuttal time?
I did not, Your Honor.
All right, do you want a couple of minutes? We'll let you have it since we,
I would like some, Your Honor.
but remember, it's rebuttal. You've done an excellent job of making your points already.
Well, just would like to address a couple of things. In terms of Officer Moore's testimony, unfortunately, the transcript is full of information that she does not have. She's basically, if you will, reading the things or allegations in the state's petition. Because once she's asked about something, she doesn't know. She stated that she does not have her file. I was asking her about information. Do you know the number you called? I don't think there's a number in the file, but you just said you made a lot of calls to them, but you don't have a number in the file. Again, her credibility was questionable. That's why I was objecting to the file. When asked did you bring your file? She said no. So what then is she testifying from? The dates listed in the state's petition. The state's asking her leading questions, so of course she can answer that. Is it the same address that's in the file? When she said, I wrote a letter, I asked, what address did you use? The same one that's in the file, but the state had already asked her that. And so they were assisting her. She, as the officer, so she claimed, did not have any information about the acts that she claimed she had done. She, again, indicated that she went to his home, but she said it was in August, but then she testified she took over his case in October.
Did this probation officer have a file
No,
that she could hand to you as the attorney for the defendant and say,
no, Your Honor.
this is what I'm testifying from?
No, and when I asked her, I said, did you get Officer Ford's file? And she said no, because I'm trying to figure out if you don't know anything and you're testifying about all these things and I'm asking about other things, you say, I don't remember, I don't recall. But her testimony is supposed to be taken as true. And we're hearing about all of these allegations that allegedly occurred under Mr. Ford, yet Mr. Ford isn't there, and there again, all of these things are coming from this state's petition, and that's not evidence. And in terms of absconding, the judge never once, in her ruling, finding whatever, say, I find that he's absconded. That was never mentioned. It was not stated that I found that he's violated. She never made those findings. And I don't want to get, but this is a judge who's been a judge, and she's, believe me or not, in juvenile court, you have to have findings. So this is not something that's new. She did not make findings. And so we're asking that this court not assume that he absconded, that the state not be given a second chance. This man has been sitting in jail ever since then because of something that started with something that he did not do. That's now gone away, that got their attention, and all of this got filed afterwards. This was not filed before. They allege that the other officer, Officer Ford, filed something, but they say we don't have a copy of it. It's not in the file because it wasn't filed. So all of this is questionable. It's questionable about what's really going on and whether the state just wants an opportunity to stick it to Mr. because he had a trial and didn't get the time they thought that he should get. And I think there's some mention in the brief about those things because of notations on his file about things that he's already been tried for, things that have already been resolved. And we think that this is a prosecutor who's just, he wants to get Mr. Hopkins. And the state is doing things that should not be done, and it's not fair. And we're just asking that this man be allowed to resume his probation, even if it's for the 4 years. I'm sure he'd rather have that to be locked up for 4 years. That could have been done 5 days from now. So we're just asking that justice be done today.
All right, thank you, Ms. Suttle. Thank you, General. We're going to take about a 10-minute recess.
All right.